Listen up. Tonight's case reads like a movie. 2 assault counts. A fight that spills out of a nightclub into a parking lot. Visible injuries, and a defendant who says nothing happened. We've got a judge already warning about bail. Conditions a defendant who later admits he's a boxer, and possible probation trouble in another county. Stay with me. By the end, we'll unpack what those punches mean in court, who's at real legal risk, and the single detail that could turn a misdemeanor into something far more serious. Ready? Let's break it down.
Good morning, sir.
Mr. Richardson, you're charged with 2 counts of assault. You're facing up to a year in jail and/or a $4,000 fine on each of your cases. We were going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On August 31st, 2024, an officer was dispatched to an assault at the V-Live Club at 6603 Harlan Drive, Harris County, Texas. The officer observed the complainants and the defendant that had moved to across the street in an open parking lot at 6440 Southwest Freeway in Harris County, Texas. The complainants were yelling for help and several males surrounded the defendant. One of the complainants stated that she and her friends were in the club. She observed the defendant, a stranger, touching and pulling on her friend, another complainant. The first complainant observed her friend scoot away from the defendant. The defendant continued to approach the second complainant and continued to touch her body. The second complainant once again moved away. The first complainant grabbed the second complainant and physically moved her away from the defendant to show him his presence or company was not wanted. The defendant used his hand to grab the second complainant's face and cheek area, pulling her towards him. The second complainant threw a punch at the defendant. The defendant threw her to the ground and punched her several times with a closed fist. The first complainant began to fight the defendant to protect the second complainant. The defendant struck the first complainant several times all over with a closed fist, causing pain. While the first complainant was trying to explain to security what happened, the defendant punched her in the face with a closed fist, making contact with her jaw, causing pain. The first complainant became lightheaded and felt dizzy. The second complainant stated that she was in the club with her friends. The defendant, who was a stranger to the complainants, approached her and began to touch her thigh and leg area. The second complainant stated that she moved away from the defendant. He touched her again and brushed the bottom of her breast. She moved away from the defendant once again. The defendant then grabbed her by her face and cheek, and she punched the defendant once. The defendant grabbed her by the hair and threw her to the ground, ripping her weave from her hair, causing pain. The defendant then began to strike her several times in the face with a closed fist, causing pain. The second complainant.
Okay, pause and take in what the officer just described. Multiple witnesses, unambiguous physical contact, visible facial bruising, and a long red mark consistent with being thrown down. That combination is what gives the prosecution probable cause. Eyewitness statements, plus corroborating injuries. Legally, this isn't just he said, she said, the facts line up. Notice too how the complainants repeatedly moved away before being grabbed. That's important for showing lack of consent and the defendant's repeated unwanted touching, which can elevate the severity of an assault allegation. Also, the defendant's flat denial, nothing happened, is a common instinct. But in court, it rarely helps if the evidence contradicts you. Now, thinking like jurors for a second, do the medical observations change your instinct about credibility? Drop a quick comment. Who seems more believable to you? The witnesses who had injuries or the defendant who denies everything?
Stated that she fought the defendant back while she was on the ground. Officers observed injuries on the second complainant's face, spots of red blush/bruising the size of a nickel, a red mark approximately 4 inches long on her shoulder blade, consistent with being thrown to the ground. The defendant stated that nothing happened and he just needed to go home.
Mr. Richardson, I'm going to find that there's probable cause to go forward on each of your cases. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you as a condition of your bond not to go to any nightclubs, bars, or any place where more than 50% alcohol sales are done. Do you understand?
Sir?
If I find that you violate these conditions, I'm going to put you in jail. And I'm going to tell you now, I'm going to make your bond so high that you're just going to spontaneously combust. I will do everything in my power to protect every single person of Harris County. Do you understand?
Sir?
No contact with either of these people, no weapons as well. Do you understand?
Sir?
What do you do for a living? Say that again.
Big reveal and a huge red flag. The defendant admits he's a boxer. That matters. Normally, fists can be ordinary objects in an assault. But when the defendant has specialized training or uses their fists in a way that shows enhanced capacity to cause serious injury, prosecutors can argue those fists are effectively a deadly weapon. In this context, that's how charges can leap from misdemeanor assault to a second-degree felony with drastically higher exposure. Also, he's on probation for prior robbery-related matters in another county, which multiplies the risk. New arrests can trigger probation, revocation, and immediate warrants. The judge's tone here is deliberate. He's warning Mr. Richardson that bond conditions will be tightly enforced and violations could send him back to custody fast. For viewers, does knowledge of the defendant's profession change how you view the force used? Would you expect a different legal outcome because he's a trained fighter?
You're a boxer. Holy moly. So are these deadly weapons then? Because if they allege it deadly weapons, guess who gets a serious second-degree felony? You're looking at 2 to 20 of the penitentiary on that one, on each of those. You better be careful, Mr. Richardson. Do you understand?
Sir?
What kind of income you make with being a boxer?
Well, I've just started.
You just started. So how do you make money? Where do you work?
I work at the Port of Houston.
What kind of income you make working at the Port of Houston?
Around 10. I just started, so I'm trying to get back into the flow of work.
Why'd you stop?
My twit card, I had lost my twit card.
Are you on probation or parole right now?
Yes,
Which one? Are you on parole?
probation
Where?
from Children's County.
Can you run his NCIC, please?
What's the question, Your Honor?
Is he on probation anywhere else? And what for?
Your Honor, he's on parole. He's completed his confinement to the robbery. With regards to Children's County, he's on a 4-year probation for harassment started in 2023. That's when he left.
Better be careful, Mr. Richardson. You need a lawyer. One that county figures out you've picked up with 2 assault cases here. You know what's going to happen, right? they're going to issue 2 new warrants for your arrest. For those, or at least one issue, they will issue 1 warrant for your arrest for the probation that you're on in that county. You're supposed to behave yourself while you're on probation. And when you don't, warrants issue.
Sorry, but
You want to apply for an appointed lawyer, sir?
Here's the professional take. The court found probable cause to proceed on both assault counts, imposed strict bond conditions, no alcohol, no nightclubs, no contact with the victims, no weapons, and explicitly warned that probation violations or further incidents will result in arrest and tougher penalties. Key takeaways: eyewitness testimony plus visible injuries gave the prosecution momentum. The defendant's boxing background creates a real risk of elevated charges, and his existing probation means this case could have consequences far beyond these 2 counts. If you're following this as a lesson, don't underestimate how prior records and personal history shape outcomes in criminal court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.